Good morning, everyone. I'm Dr. Dennis Khong from the Center for Law and Technology, Faculty of Law, Multimedia, the moderator for this morning's webinar. On behalf of the organizer, I would like to welcome all of you to our Insight Humanizing Innovation session with Industry webinar. Thank you for spending your time to be with us today. Today's webinar is titled NFTs Intellectual Property. NFTs, or non-fungible tokens, is a hot topic of discussion in recent years. They are considered as a form of virtual property, and some courts have started to recognize NFTs as a form of digital assets. In recent months, prices of NFTs have gone down in line with prices of cryptocurrencies, experiencing downward adjustments. Nevertheless, industry players remain hopeful that the current crypto winter will pass when global interest in using cryptocurrencies regains its pace. This morning, we are very fortunate to have Mr. Veon from the law firm Veon and Thye, which is based in Georgetown, Penang, to talk to us about this topic. Mr. Veon is a senior lawyer specializing in startup business and intellectual property law. Having commenced his legal practice in the late 90s, he has seen all the ups and downs of the world economy not once, but a few times. One lesson he learned from all these crises is that change is the only constant. Hence, he believes that for the legal profession to stay relevant and thrive, it must continue to reimagine, reinvent, and reboot itself. To that end, he initiated Veon Role, an innovation legal service brand that has adopted technology to reduce costs and risks, improve efficiencies, and increase its value to his clients. He is also a regular columnist in Chinese newspapers in Malaysia. Many audience here may recognize his Chinese name. An avid law tech and fintech enthusiast, Mr. Veon now finds NFTs, Web3, Metaverse, and all things blockchain fascinating and wants to be part of this digital revolution. Before we start the webinar by Mr. Veon, here's a reminder to all our audience who are tuning in. You can post any questions to our speakers by posting them at the chat box of this live event in Facebook and YouTube. We will try to attend to these questions at the second half of this webinar in the Q&A session. So over to you now, Mr. Veon. Thank you.
Good morning. Thank you very much, Dr. Dennis. Thank you for having me this morning at this MMU event. Okay. May I have the slides, please? NFTs. Okay. I believe nowadays a lot of people have heard about NFTs, but not many people actually understand what NFTs are, right? And this topic, today's topic, actually, NFTs, intellectual property, actually was chosen by the FMU, okay, to make it more catchy, so to speak. But of course, to a lot of people outside, maybe is how to say it's a foregone conclusion. The moment they see and they read NFT, oh, for sure, it's intellectual property. But is it that simple? I don't think so, right? Okay, so before I go straight away into that issue, maybe there are some introduction slides of me and my firm. Okay, next slide, please. Okay, everyone, this is a little bit introductions, introduce myself to everyone here. Okay, I'm the founder of Veon Law Apps. Okay, you can see at the right side of the slides. Actually, since last 2021, our firm has actually developed apps. When we talk about apps, meaning actually you can download it from Apple Store or Google Play Store. Okay. Okay, now currently I hold a certain position committee in Bar Council Malaysia, Intellectual Property, Cyber Law, IT Innovation, Future in Tech Committee. Okay, also before that, I also part of the eFintech School, Furniture Intellect School Ambassador. These are roughly my background. Okay, next please. Okay, these are a few events that I took part. Okay, just recently. Okay, this slide show that actually I was part of the Digital Revolution conference organized by Digital Penang on September 16. Okay, at Spy Arena in Penang. Okay, you can see from the speakers, actually, there are who's who there. Okay, you see the Pentas IO, and also the exchange accept, they are out there. Okay, I'm very honored to be part of it, and it's quite, I would say, a very exciting and also event to attend to, right? Okay, next please. Okay, then after that, I also took part in an event, a Twitter Space event. I don't know how many of you are aware of what is this Twitter Space. In fact, I also that was my first time I took part in Twitter Space. So actually, it's more like a clubhouse. I believe clubhouse is more well known to a lot of you all. Okay, this event was organized by Synergy. Okay, if you know Synergy, Synergy is one of the 4 licensed digital asset exchange licensed by Security Commission, right? And this topic actually is about intellectual property laws and metaverse, as it's quite a lively event. Okay, and he has received quite a encouraging response, so to speak. Okay, next slide, please. Okay, now I think it's good that I have to explain to everyone what is this talk about, right? Just like, okay, for information, you see, last week when I first got hold of the e-poster, okay, e-poster, then I started to share the e-poster to my friends' contact as usual. And then, one of my friends immediately replied saying that, are you teaching us how to make good money from NFT? Okay, for sure. He decided, I think I have to set the record straight. Okay, today, okay, I'm talking about basically talking about the legal aspect of NFT. I'm also not qualified to talk about the technological aspect of it. Okay, I'm not expert in blockchain, so to speak. Okay, I will confine my talk on legal issues. Okay, and this 7, 1, 2, 3, 4, 5, 6, 7. There are 7 topics that I will cover. Okay, first part is the context. Okay, I think the context is very important because I think when Dr. Dennis in his introduction, he has mentioned that the winter is no longer coming like what we often heard in the Game of Thrones. Winter is here. Winter for NFT is here. Okay, so this winter context that we are discussing NFT. Okay, yeah, if you all aware, actually, last year this time, NFT was riding high. Okay, together in parallel with blockchain, but this year totally a different story altogether. That's why I think the context is important. Okay, yeah. Then second topic I will touch on is a brief brief interplay between NFT, cryptocurrency, and blockchain. Again, I have to be clear from outset. I'm not expert in technology aspect of it. I think it's the nut and bolt. I would say the nut and bolt, meaning we need to know the basic concept of NFT, cryptocurrency, and blockchain. So I will have light touch on this topic. Okay. Then the third subject, okay, I will talk about NFT, intellectual property. You see the heading of the topic, I purposely strike off intellectual. See, you see, before intellectual property, there's a thing called property. Okay, it seems easy, but actually later when we discuss further about the case law, you notice that actually it's not as straightforward as easy as we would have thought, right? Okay, then the fourth, I will discuss a bit NFT related legal issues arising from the cases, okay, decided recently. And fifthly, I will talk about the NFT interpreter. Finally, okay, I think it's good that we talk about the broad relationship between NFT and property. Then only will zoom into NFT interproperty. After all, interproperty actually is a subset to property, right? And then part 6, again, I will do some discussion on a few cases, about NFT and intellectual property. Okay, and finally, okay, after traveling the whole world, I will come back to our home Malaysia, okay, and talk about NFT in Malaysia. NFT as it is in Malaysia. Okay, I'm talking as it is, not as it ought to be. Meaning that we are talking about existing legal framework and existing condition that is currently prevailing in Malaysia concerning NFT. Okay, and finally, as usual, there's a Q&A section. Okay, so hope you all have a better understanding of the whole structure of the talk, so that easy for you to follow later. Next slide, please. Okay, now the context. I think as I mentioned, the context is very important. Okay, and you see from the slide, left-hand side, okay, it's a Bloomberg.com. The title is NFTs to be scrutinized by UK Parliamentary Committee. It's quite recent. It's just 5 days ago. Okay, what happened? Okay, it's important. You see, in a very short statement, I believe the Parliamentary Committee of the United Kingdom has actually made 4 very pertinent and important points. Okay, point number 1. Okay, the committee says UK regulation of NFT is non-existent. Okay, I think this is true over the world. Okay, whether in US, in Malaysia, even the EU, all are the same. Okay, basically it's non-existent. NFT is the wild, wild west, so to speak. Okay. Secondly, okay, so second point made by the committee in its very short statement is touches on whether NFT investor, especially the vulnerable speculators, are put at risk by the market. This concern again is widely shared across the world, right? Even in Malaysia, we all know that actually for the past 9 months or so, a lot of people got burned. Okay. In Bitcoin, NFT, all these things. I think that is the part that the vulnerable sections that I think is the government responsibility to look into how to fix, not to say fix it, I think how to cushion it and how to provide some sort of protections. Okay, is the responsibility of the government. Okay, and then the third point is also a fact. The winter now currently is the winter of NFTs and Bitcoins, all those related things. Okay, trading of NFT has dried up this year as crypto prices fell. Okay, this is common knowledge now. Okay, then number four is equally important. Okay, is that the UK Parliamentary Committee also has acknowledged. Okay, despite all the shortcomings and the falling prices, whatever, right? The wider benefit that NFT and the blockchain could provide the UK economy. This equally applies across the world. Okay, that's why I think based on these 4 points, I believe the outcome of this committee that look into the NFT and blockchain issue will be closely watched by a lot of people. Okay, next slide, please. Okay, now. Okay, before we go straight to the main theme, meaning that NFTs, the property, I think it's good that we grasp some nut and bolts of NFT. Okay, meaning we have some basic understanding of what is the technology behind these apps. You see, these apps, if you all have some information of knowledge or read somewhere in news or social media, I think it's quite a familiar faces, apps faces. Okay, these are arguably during the height of NFT and blockchain. I think it's hot. It's very hot, and in fact, owned by a lot of celebrities, including Madonna and a few others. Okay, next. Okay, now we talk about NFT. You kind of away that you have to discuss or touch on cryptocurrency and blockchain because NFT, just like cryptocurrency, actually, they both are built on the blockchain technologies, right? Blockchain technologies. Okay, so again, I have to stress that I won't go very deep about the technology aspect of it because I'm not expert it. But I think some basic concept, I think just like nut and bolts that build up this NFT and infrastructure. I think we need to have the basic understanding of concept. Okay, next, please. Okay, now, you see, I try to use layman terms and very plain language and as minimum technical phrases or terminology as possible. Okay, so this is not legal definition for sure. And after all, there's no law statute that really gives a legal definition until up to today. Of course, from time to time, the courts everywhere try to give some form of definitions. But at this stage, we are not going to that. I just give a basic explanation of what NFT is. Okay, and NFT is a digital asset. Okay, you just understand one thing. Forget about everything. It's a digital asset. Okay, exists on decentralized digital ledger called blockchain. Okay, I try to make a simple. So meaning, remember, NFT is a digital asset, and it only exists on decentralized digital ledger called blockchain. Okay, and it comes in the form of art, music, in-game items, videos, and more. And they are bought and sold online with cryptocurrencies. This is important. You see, from this, from here you can see that actually both of them are together: NFT, blockchain, and cryptocurrencies. Okay, and of course, one of the key features I believe is very important and make NFT extremely useful is that actually NFT can be used as digital certificate of authenticity. Okay, meaning can prove ownership of digital assets. Okay, to put it to good example, okay, analogy, you see, like property, you need the land title, right? Again, for digital assets, again, you can NFT can actually function as a digital certificate of authenticity or proof of ownership. Okay, in that sense, right? Okay, blockchain. Okay, blockchain again is it look very technical, but actually we just describe it plainly as a digital record of information. It's a distributed across network. Okay, so because it's distributed across network, it's decentralized, meaning that it's extremely difficult or close to impossible for anyone to try to tamper with it or infiltrate it or change it. That why make it in a way it's very relatively safe as through all the centralized system, okay, that we have in world today. Okay, and then of course, finally talk cryptocurrency. Cryptocurrency is a medium exchange, okay, such as US dollar, but it is in digital and uses encryption techniques to control the creation of monetary units and to verify that the transfer of funds. Okay, basically, you see, these slides talk about the basic concept of NFT, cryptocurrency, and blockchain. Okay, so it's just a basic concept. Okay, a basic concept just to understanding introductions. Okay, hope it can help clear some air. Okay, and you all can are free to read up further about it if you are interested. Next slide, please. Okay, now come the main theme of today's talk, right? Okay, the title given by the organizer is NFT intellectual property, right? Okay, but when I researching this topic, I discovered that before we discuss about NFT intellectual property, I think you see we have to first talk about NFT property. Okay, because before intellectual property, there's a thing called property. Okay, it look again, it look extremely nonsensical for us to ask this question, but later, shortly, you find out, actually, you see, in fact, a lot of cases when appear before court, right? The first question, the so-called threshold question that the court invariably would ask is, are NFT property? Okay, it make it very fundamental and very significant. Okay, so that's why I purposely for this topic I strike off the introduction and we focus on art NFT property. Next, please. Okay, now why this why the importance of the property questions? I think I believe these statements summary statements provided by the UK jurisdictions task force. Okay, actually this jurisdiction task force focus on cryptocurrencies and not exactly on NFT, but I believe the rationale equally applies to NFT. Okay, so let us see how we summarize the importance of the property issues when it comes to cryptocurrency and also NFTs in that sense. Okay, it reads, why does it matter if a cryptocurrency asset is capable of being property? It matters because in principle, proprietary rights are recognized against the whole world, whereas other personal rights are recognized only against someone who has assumed a relevant liquidity. Proprietary rights are of particular importance in an insolvency where they generally have priority over claims by creditors. Okay, and when someone seeks to recover something that has been lost, stolen, or unlawfully taken, they are also relevant to the questions of whether there can be security interest in crypto assets and whether a crypto assets can be held on trust. Okay, from to sum up, why this property question important? Because later we will find out from the case law. Actually, you see a lot of the threshold question why they ask property, because especially for a lot of cases when involve unlawfully taken NFT or NFT stolen, or mistakenly transfer, all these things, right? Before the court can grant the remedies of relief applied, by the applicant, the court would ask this question, the fundamental question, whether NFT can be considered property. Because if they are not property, then the court cannot issue the remedies sought by the applicants. For instance, is an injunction. That's why it's extremely important. Also, the issue about whether NFT can be described as securities, can be described as commodities. All these things will come into play. That's why the threshold question invariably before the court has always been whether NFT is property. Now, next please. Next slide, please. We'll go into a few cases that actually discuss and decided on these issues. The first case that we will discuss is this UK case, Lavinia Deborah Osborne versus person unknowns on Zone Network in trading as OpenSea. So we call OpenSea case. If you all have some basic understanding of NFT, right, you all should know what an OpenSea is. OpenSea is one of the most popular exchange, platform for marketplace for NFTs, right? In this case, the OpenSea case is the first English case that addresses the property issue in relation to NFT. You see this case, litigation of comments by Lavinia B. Osborne, a founder of Women in Blockchain Talks, after two of her NFTs from the Boss Beauties collections were transferred out of her digital wallets without her consent. Osborne was able to trace the NFT to two specified wallets on the OpenSea NFT marketplace but was not able to identify the individuals who own the wallets in question. And this is quite common. You see later, in fact, there are some of the cases actually are all involve stolen NFTs or mistakenly transfer, all these things. So these are the key issues confronted by the court. Okay, and you see in this case, Osborne came to the court and applied for an interim injunction to freeze the assets until the end of proceeding. And you see, this interim injunction to freeze asset is an order that can only be made against asset defined as property. You see, so the threshold questions in this case. I think in any other case, in other jurisdictions also they face the same problem. Okay, and the court in this case ruled in Osborne's favor in the process, recognizing NFT as a property. You see, in this case, it's ruled that NFT is property. Okay, so at this stage we are talking about NFT's property. Okay, we are not going to talk about NFT is the property yet. Okay, so in this case, it's clear cut. The court rules that actually NFTs are property. Okay, the interim freezing injunction was issued against the identified individuals who own the named wallets, as well as OpenSea, the platform hosting their wallet. You see, another important rulings of this case is that also the marketplace, like OpenSea, Mintable, all these things, they can be held liable, accountable for whatever mistake happen under their watch. Okay. Yeah. Next slide, please. Okay. Now, okay. This case is from Singapore. Okay, our neighbor. This Singapore case. This case actually, if not mistaken, this case was decided somewhere in April or May this year, but the written grounds were actually published last month. Okay, the written grounds by the judge only published last month. Okay, so okay, again, this Singapore, in this case, a Singapore man has won a court injunction to stop the sale of NFTs that once belonged to him and was used as collateral against a loan. You see, this is also important. You see, involve NFT being used as a collateral for a loan. Okay, you see, normally, we will charge our house or even whatever machine, whatever, as a collateral for a loan. But in this case, NFT, can be function as collateral. Okay, and to get a loan. Okay, in this case, the claimant and the responder enter into a loan agreement on 19 March, whereby claimant transfer BYC to NFTs to be NYFTE to be held until he repaid the loan to the defendant. Okay, it was stipulated in the agreement that the claimant would never relinquish ownership of the NFT, and if he was unable to repay the loan in time, an extension of time should be given prior to the foreclosure or foreclosure. Okay, but when the claimant found himself unable to repay the loan in time, the defendant, in violation of the contract, shifted the NFT to their personal Ethereum wallet and listed it for sale on OpenSea. This is the case, you see, meaning involve breach of contract. Okay, all these things and also again, in this case, it's somewhat similar to the OpenSea case in UK or Osborne case UK. Okay, it's involved that transfer of NFT without the consent of the original owner. Okay, and also in this case, the applicant, the original owner, also rushed to the court, trying to get interim injunction to freeze the account to prevent its NFT being transferred out without his or her consent. Okay, next slide, please. Okay, now there are a few very important rulings made in this Singapore case. See, first thing, okay, on your left-hand side, you can see in his ground of decision issued last Friday. Okay, you see this one actually is in October. And we also, even though I think, if I'm mistaken, this case decided either April or May this year, 2022, but actually the written ground was only published last month, October. His ground of decision issued last Friday, Justice Lee Siew-kin held that NFT could be considered as property, okay, as they fulfill certain legal requirements such as being easily distinguishable from one another and having owners capable of being recognized as such by third parties. Okay, I think this summary of it. Of course, I think the learned judge has provided quite an extensive reasoning in arriving at this conclusion. But I think the gist of it is that I think it fulfills the characteristics of property. Okay, that's why the judge ruled that NFT could be considered as property in this case. This is very significant. Okay, okay. Then another part of it, you see, right hand corner of this slide. In passing, okay, in his ground decision, in passing, the judge also said the description of PYC number 2162 by Mr. Janet's lawyers, there is a very unique artwork and the only one existence, was not quite accurate. Okay, this finding of facts. The picture of the NFT exists as an image file which can be copied many times over, he said, JPEGs. Okay. I see. I can see Dr. Dennis smiling. You know, I believe previously I remember. I think when we discussed it before, this was the line taken by Dr. Dennis. The JPEG file can easily copy and duplicate. Okay, and you see that's what the judge ruled in this case. You see? What is truly unique and irreplaceable here is the string of code that represent the NFT in blockchain. Okay, this is something I would say is a finding of facts. Okay, it's facts. It think that this should be the case, and not the JPEG files as normally argued by laymen. Okay. Okay, but okay, before that, okay, sorry, go back again. Okay, okay, bear in mind, this case is interim injunctions. Okay, this ex parte, so to speak. And in fact, to be fair, the judge made it very clear. Okay, he said this decision and his ground of decision was decided based on hearing one side and not both sides, right? So he said he might decide differently. He might decide differently if he got the benefit of hearing both sides. So we are bearing in mind that this ex parte hearing, okay, and it's an interim injunction. It's not permanent injunction as yet. Okay. Okay. Next slide, please. Okay. Now, this is another point that is very interesting. Okay, arising from this case, is that okay? In this Singapore case, Justice Lee allowed Mr. Janet's request to serve court paper, okay, on the defendant through Twitter. Okay, interesting, right? Through Twitter and chat platform Discord. Okay, for those who are into NFTs, you're all very familiar with this thing. Twitter and Discord are the two platforms, must-go-to platforms. Okay, in fact, I think those NFT enthusiasts or fanatics will tell you that they literally pick up the trick, okay, from Twitter and Discord, okay, and not really not from schools, okay, from Google as well. It's from Twitter and Discord. Basically, all those investor, creator, actually they are in these two platforms, Twitter and Discord. Okay. You see, that's why in this case, understandable that the judge makes such a ruling saying that you can serve court paper on defendant through Twitter and the chat platform Discord, as well as the messaging in messaging platform in the wallet. Okay, and you see, he also explained that actually there's a possibility that the cost paper and the unknown person can identify eventually, through these platforms. Okay. Okay, now then, okay, there's a Twitter. I Twitter you. I Twitter you the cost paper. Okay, now, okay, that's another UK case, which is equally important and significant, is that what they call be a lawyer versus person unknown and Binance Holdings. Okay, and this case also a landmark case in UK where the English High Court granted an order allowing service of proceeding on person unknown via non-FD on the blockchain. What does that mean? Actually, this is what we call airdrop view. Okay, airdrop is a how to say terms exclusively used, unique terms exclusively used by in NFT world. Okay, meaning that you minted the cost paper in FT and then send to your wallet. Okay. Yeah, this is interesting, right? Okay, we need to serve the proceeding. You see that's exactly why how the lawyers apply help the applicant apply to court to serve proceeding outside the jurisdiction via both email and FT in the form of airdrop into the digital wallets, where the claimant make his first transfer to the person unknown behind the fraudulent websites. Okay, that's what we call the airdrop. I airdrop you the cost paper. You see, it is very interesting, right? You see, nowadays, no longer register post, okay, or personal service. See? Now we have coming from WhatsApp you, okay, Facebook use, Twitter you, and now airdrop you. Okay, this will be follow the development of technology. Okay, next. Okay, again, there are some side issues, legal issues, but not less significant. Okay, the first is also from the Singapore case about jurisdictions. Also, in that case, the judge also held that Singapore courts could hear cases related to blockchain despite their decentralized nature. Okay, also for lawyers. Okay, even for those solicitor or advocate arguing in court or lawyers that drafting whatever documents about this, the jurisdiction clause is always an issue when it comes to digital transactions, and more so for NFT blockchain thing, right? It's decentralized. Okay, it's difficult to identify where's a proper forum, okay, to adjudicate and to hear the thing. But in this case, the issue was raised, and the court ruled that actually Singapore courts has jurisdiction to hear the case. Okay. And another issue, of course, in the UK case, the Avaya case, also is the liability of crypto exchanges. Okay, the court set a precedent by making the alleged party serve through blockchain, meaning airdrop you, and added that the crypto exchanges are responsible for keeping track of the exploited asset so that they don't move out or withdraw. You see, meaning again, this case also stressed that the exchanges let's say if they say the what we call DEX digital asset exchanges. Okay, in Malaysia, you all know there are 4 licensed exchanges: Luno, Synergy, and 2 more. Okay, meaning they are responsible. You see, whatever court case involving this fraudulent transfer or whatever, normally they will be cited as one of the defendants. Okay, next. Okay, now we have covered broadly the NFT property and the related legal issues, right? Now we finally move on to the title, okay, the title given by the organizer, NFT and intellectual property. Okay. Now we will try to touch on a few issues pertaining to this NFT and intellectual property. Next slide, please. You see, I think unlike surprisingly, or ironically, unlike the like the property issues, the threshold issue of whenever the parties or litigants appear before court, the threshold issue of property. Surprisingly, NFT as intellectual property, it seems that never an issue before the court. Okay, because it's given as if it's given that treated that okay, you go to court NFT if you cannot copyright, trademark, and of course part is contract licensing. But these are the three areas of law that I would say is getting more and more flooding our courts. Okay, so this is the simple thing. Trademark is a protect brand owner, creator. You are creator or you as author as described under the act. Okay, you have copyright. Okay, IP rights protect the owner of the property from unauthorized use by others. Okay, I don't want to go because it's very simple and basic. Okay, next slide, please. Okay, now I will talk about some example of NFT related IP issues. Okay, no longer it's more specialized and focused on IP issues, right? Next slide, please. Okay, now you see in NFTs from the copyright issues, it's the elephant in the room. Okay, you see there's a lot of this confusion and dispute over who actually owns copyrights in NFTs. Why such confusion arises? Because actually, contrary to common belief, actually there are three parties involved here. It's not between the creator of NFTs versus the investor or buyer. Actually, there's another layer, meaning the copyright owner of the work and the creator entity which convert the copyrighted work into NFT. Okay, this is what we call the creator of NFT, and the creator of work or the copyright owner of the work, and another part is the investor or the buyer of the NFTs. These three parties. Actually, that's why I'm a little bit confused, right? But the rule of thumb is this. In general, buying NFT does not mean you own the copyright in the underlying work. Okay, bear in mind there are three parties. Okay, bear in mind that as long as the creator or the minter of the NFT is not the copyright owner, then you have to be careful. Okay, because if you buy or invest in such NFT, that won't automatically mean you meaning that you own the newly acquired NFTs. Okay, this is a rule of thumb. Remember that. Okay, next slide, please. Okay, now the copyright questions. Okay, we all know that copyright provides a bundle of rights which are exclusive for the owner of the copyright in the work. Okay, these rights include the right to reproduce, prepare derivatives, distribute copies, whatever, blah 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 blah. Okay, we are not on IP law seminar today, so we just skip it. Okay, but the more important thing is that I mentioned just now, the creator of an NFT, meaning that the person or party that mint is the person that create the NFT, not necessarily is copyright owner. Okay, the creator of NFT would need permission from the copyright owner of the work which they are embedding in NFT and offering for sales. And this is important. In fact, I can tell you, I have a few clients. Okay, they actually they have gone ahead and to create NFT on a few famous artworks, whatever, or even cartoon, whatever lah. But I think I advise them better not. Okay, you are running the risk. Okay, so you better be careful of all these things unless you get the permission from the copyright owner. Okay, this will name the field. The field is that you see like DC Comic and Marvel, where all these famous IP, so to speak, you have to be careful if you want to use their characters or image, whatever to create your NFT. You have to be careful because it's nowadays like all digital world is connected world. Through internet, easy, for them to track you and even for them to send you issue cease and desist letter. And now that the law seems to suggest that they can WhatsApp you, email you, and even airdrop you, right? So you have nowhere to run. Okay, you have to run and come to this. Okay, and then then another part that you all have to be careful is as a buyer of FT. Anyone who is buying an FT should consider the legal rights and implication of each NFT platform and each specific NFT before purchasing. Example, provision of commercial use of NFT. And this is important. When the licensing issue comes in. Okay. Later there are a few cases that in the case study that you see how important is this licensing terms and conditions. Okay. Next, please. Okay, this is interesting. This is a case where the production company Miramax sued the famous director Quentin Tarantino. Okay, we all know about fictions, right? Okay, this case is very interesting and important. Is that it highlighted the interplay between the contract, IP, contract, trademark, and copyright. Okay, in this case, actually, Quentin Tarantino was given a right, okay, limited right, okay, to do certain things using the copyrighted word of this movie to do certain things. Okay, but in this case, the directors plan to create NFT from the 7 exclusive scene in the movie and auction it off. And this was stopped by production company saying that this has infringed the contractual terms imposed, limited right use of them to impose. Okay, and you see, that's interesting, important case. But fortunately or unfortunately, this case they have settled. Oh God, we don't get to really see the full argument and the actual ruling by the court. Okay, next please. Okay, then these they are two very good examples to demonstrate very important about knowing and learning, knowing what you are buying. You see, in consumer law is KVM law, right? But in NFT, what they call is DY. Do your own research. Do your own research. DY. Do your DYOR. Do your own research. Equivalent to KVM law. Okay, it's like, while most NFT creators restrict commercial use, there are certain creators that give more expensive right to NFT owners. Okay, in this case, like the famous ball apes, your club, right, have commercial usage right to the apes, meaning they can make and sell heads, and marks. Okay, meaning in this case, you bought the NFT from BYC, right? You can really adapt it and use it for some commercial use. Again, also the CryptoKitties, CryptoKitty also have some rights under the license terms and can commercialize their own merchandise as long as the revenue does not exceed 100,000 annually. Okay, you see that there are terms and conditions there. Okay, it's vary from one platform to another platform, one creator to another when it comes to NFT. Next, please. Okay, now NFT and trademark. Okay, this is arguably there are a lot of cases now, especially in US, Okay, so let us find out. I think I would say it's quite interesting. In fact, all these cases are still ongoing. Okay, it's quite new, right? It's developing. Next, please. Okay, before that, you see, this is important. I think this is quite a new one. In August this year, only, the Sony Music, they already filed trademark for the Columbia Records logo, claiming plan to use for NFT backed media. Okay, so now you see, those who are well versed in trademark law, you know that there are 45 classifications, right? Then the first question to ask is, if I want to protect, if I want to go into NFT and try to trademark, to protect my trademark for NFT, where should I go? I think this gives some hints. Actually, you can really file trademark to protect your NFT back related products or even services. Okay, next. Okay, this you see Hermes. Hermes. Very luxurious, good bag lah. In this case, see the French luxury brand Hermes actually sued an artist or Charles artist because he produced and sold Meta Birkin NFTs, which are digital image of the furry version of Hermes Birkin bags. Okay, and Hermes, as usual, argue that Meta Birkin NFT infringe on its Birkin trademark. Okay, meaning that you have dilute the thing, also confuse the consumer that actually that your this Meta Birkin NFT actually come from the luxury brand Hermes. Okay. But in this case still ongoing, not yet concluded. But it's important is that actually you see nowadays a lot of NFT, they created a lot of these famous mark or luxury mark through NFT, and I believe there can only be more and more cases like that floating to court. Okay, it's quite interesting to see how the court decide. Okay, next please. And this another important for well-known mark, Nike, well-known mark owner. This case important when it comes for utilities. When talk NFT, right? NFT beside those who use for investment purpose, whatever, and raising fund, whatever, I think but they commonly use utilities part, how to apply it to common business use. And this is a good illustration of that sense. Okay, this legal battle between Nike and StockX. StockX actually is a marketplace, online marketplace for these shoes, whatever. Started over non-NFT, which are unique digital assets that consumer can buy and sell. Okay, Nike sued StockX, saying that online marketplace NFT of Nike shoes infringe on trademarks and could confuse consumer. But the StockX counter that it says it uses NFT to track ownership of physical product, as well as to increase efficiency and decrease cost for its customer. It is interesting, one of the arguments advanced by StockX said that, no, actually, we are not selling the NFT. Actually, NFT actually is something like a digital receipt. Okay, you pay, you give the digital receipts, and then you go to the physical store. Okay, and then collect your shoes. Okay, are they supporting? It's something like the counter argument that it's no different from catalog, right? You purchase through the catalog, and catalog will have to show Nike or the photo, whatever there. This interesting thing. Again, this is ongoing, and is I would say keenly watched by all across the world about its impact. Okay, next. Okay, then finally we come to our home. After traveling from UK, Singapore, and US, right, we come back home, Malaysia. So what is the position in Malaysia? Okay, to be frank, unlike Singapore, I'm not sure, but as far as I can recall, is that there's no such case law. For sure, there's no law regulations specialized, especially regulate NFT. Again, also there are no actually case law that really discuss and rule on NFT. But actually, we have one case on cryptocurrencies. It's what the Robert Ong case. Robert Ong case, I think is I would say is a must read for all those who want to be in NFT, cryptocurrency, and blockchain. Okay, this is the first time that Malaysia law make some pronouncement. From there we can see our judicial attitudes when it comes to handling this new technology and new kids on the board. In this case, important in the sense that you see again, this case was actually filed in 2017, decided by Session Court in 2018, and then the party who not happy with the decision, Session Court decision, appealed to the High Court, and the High Court handed down the decision in 2019. Yes, you see, all this case actually before Malaysian government through SC issue the license for the digital asset exchange. You see, this all happened before the Malaysian government actually stepped in and actually, so to speak, regularize the digital asset exchange. It's important. In this case, important in the sense that actually, you see, the defendant in this case actually raised the issue that cryptocurrency is illegal, okay, in Malaysia at that time. So we cannot sue them for that. Okay, very important. You see, if you read this statement, sorry, it's a bit. Can you hide bigger so that I can read the statement? Okay, yeah. Okay, you see, it's important. You see, in this quotation, quote unquote, Bitcoin only existed in the virtual world and where Bitcoin did not take any physical form and was not tangible. Therefore, Bitcoin could not be anything under the Contract Act. Really interesting in this case, the court has resorted to 1950 Contract Act, okay, to decide that actually whatever thing, anything mistakenly transfer, you have to repay back. Okay, in that case, the court held that actually, the Bitcoin in that case actually can be fall under anything under the Contract Act. Okay, this is a very interesting case. Okay, next please. These are the three issues raised in that this local case, securities. Okay, that's what the High Court held upon appeal. Cryptocurrency is not money. As we know, in the traditional sense, it has been recently defined as a form of securities. Okay, by Section 3 of the Capital Market Services, okay, Order 2019. You see, this regulation also only came in 2019, while the case was first filed in 2017. Okay, well before this. Okay, then second thing, commodities. The respondent will also correct that it cannot be disputed is a form of commodities. As real money is used to purchase the cryptocurrency, in this regard, there is indeed value attached to Bitcoin in the same way as value attached to share. Okay, in this case, although the High Court ruled that cryptocurrency, Bitcoin in this case can be commodities, anything. Okay, Section 73. Rightfully, Bitcoin ought to fall under the ambit and application of the term anything under Section 73 of the Contract Act, and therefore the appellant is bound to return the same to the respondent. The consumption warrant it in this regard. The term anything is plainly wide enough to cover Bitcoin. Okay, you see, in this case, the court has to resorted to the Contract Act, okay, to try to do justice. Okay, next. Yeah, you see, this now currently we have 4 DX, what we call registered digital asset exchanges. Okay, it meaning it's issued and licensed and regulated by Security Commission. Luno, FX Global, Synergy Tokenized Exchange. Okay, these are the licensed and regulated body, meaning in a way it's recognized as securities. Next. Okay, that's it for now. Sorry, I think I've taken quite a long time to share. Thank you for bearing with me. Thank you.
Thank you very much to our speaker today, Mr. Khaw for the very interesting and informative sharing on NFTs and the law. A reminder to all our audience online, you can post a question to the speaker through the chat box in Facebook Live and YouTube Live next to this video. While we wait for questions from the participants audience here, I have one question to Mr. Khaw, and perhaps we could discuss this question. Mr. Khaw, what do you think? Do you think the Parliament should make law to govern virtual properties such as cryptocurrencies, NFTs, property in metaverse, rather than letting courts develop the law on an ad hoc basis? Because I can see that from different courts, different jurisdictions, they have taken different approaches to this fundamental question on whether cryptocurrencies, NFTs are property, and as such, other areas of law such as contract law and equity should recognize them and be able to provide proper enforcement decisions and proper enforcement mechanisms. What do you think? Should Parliament get involved into this game? And if so, what would be the key concerns, key provisions?
Okay, thank you. I think these are very good questions. I believe a lot of people asking questions around the world, not only in Malaysia, even advanced country. They say from the beginning, the context, when I mentioned about UK Parliament, they actually setting up a committee to look into that, right? Meaning, again, the 4 key things whenever we deal with issue 4 key things, we have to admit that as of today, the wild wild west. Okay, there's no regulations. Okay, in our case, you see, in even Malaysia case, they have to for this digital world, they have to use 1950 Contract Act. Okay, try to apply the traditional legal principle, to cover that lacuna, so to speak. Okay, and okay, my personal view is this. I think for whatever thing we talk about creativity, talking about innovation, something like very disruptive development, right? I think is the government should be slow, okay? Should be slow, and they must not be too harsh, too fast, okay? If it overreact, meaning that they come down too harsh, too fast, trying to control, trying to manage, and worse, trying to how to say, restrict. I believe that would be counterproductive. If we want to really develop, you have to let it develop and also develop, okay, so that we can see advancement that can really new thing develop that can really improve efficiencies and provide better value to the world. Okay, I believe the better way will be incremental, like a light touch approach. How we call light touch regulation. I think Dr. Thanks, you are light touch regulation. Something to do, something like Airbnb. Okay, it's too closer as Airbnb, even like Grab, okay, or Uber, right? All these things, right? They are there to disrupt the establishment, the existing order, okay, meaning that they free up the market, making it more efficient, cheaper, better service. Okay, these are the if let's say you imagine that during the 2008 or 2009, where Uber and Airbnb started to hit the market, right? You imagine if then the government really acted harsh, fast on them, then I think we would not have Grab, Airbnb, all these things, right? That's the way. I think the better way is that light touch approach. We have to monitor it. Of course, the government has to step in whenever vulnerable public estates, right? That then we will take it from there. So my view is that light touch approach, government shouldn't be overreact, shouldn't we come down too harsh, too fast, and then that would crash the whole innovative and creativity part of the technologies. This is my personal view.
Thank you very much. I suppose since you mentioned about protecting consumers and investors protection, lately we have also seen in NFT markets this phenomena called rug pull, where a creator of NFT, after selling NFT and promising all seeing values and collecting all the real money, that they have actually removed or close up the NFT platform. So that the purchasers of entity eventually found that what they have purchased are no longer there. I think these are some of those current issues. And on top of this, I can see the taxation issue is always there. Should there be a property gains tax on NFTs? Is that a profit? Should we consider it as a profit when parties exchange NFTs for value and there's an increase in prices? Obviously, money laundering concerns are also there, that you're buying it for nothing and then it's just another way of passing money from one party to another using NFTs. And during the early days of the Ukrainian war, people were also talking about converting Ukrainian money into currencies, into cryptocurrencies and NFTs as a safe way of storing the property on thumb drive. So what do you think of some of these questions?
I think this I would say is a clear and present dangers that brought about by these NFTs and in fact, for information, right, you're talking about the tax issues, right? I think our Inland Revenue had issued circular, whatever, saying that they will tax if you make profit out of trading NFTs. I think already from time to time, right? And Inland Revenue issue circulars, whatever, advice, and it's as good as law. As good as law, we have to follow. Okay. And also talking about the fraudulent money laundering things, I believe I read somewhere in UK the Royal Custom also started to seize NFTs when come for the tax fraud case. Okay, in that case, basically it's very added tax. As usual, the merchant, the businessman, they always try to overclaim, all this thing. The Royal Commission, Royal Custom in UK, and seize the NFTs as has been used, which has been used as in part of the greater tax fraud schemes. Okay, all these things are happening now, and in fact, you see, in US in particular, they have I believe, extend the conventional consumer protection law and security laws as well, okay, to NFT sphere. I think you're talking about influencer, right? Influencer become promoting all these exchange of NFT products. I think Kim Kardashian, okay, lately he was charged, fine, for misrepresenting, and because he didn't disclose that actually he received money when promoting certain NFT products. Okay? I think there's no lack of existing law that can be adopt, and adapt, okay, to these NFT related commercial transactions. Okay, that's why I believe we don't want to rush, okay, to create another grand scheme of legal framework. In fact, the better way I think is to from time to time incrementally, we extend the existing legal principles, okay, to NFT related transaction or NFT related frauds cases are there. I think this should be a more effective, I would say, effective way, and of course we're about to have some trial and errors, but it's more effective than you trying to create something whole new, can be white elephant, and not effective and costly as well. Okay, this is my personal view on the question posed by you.
Thank you. Very good comments and a lot of points for us to consider and develop further. I've got a question here from Mr. Aris. The question is there any differences between NFTs, IPs, and conventional IPs that we have today? Thank you.
Sorry, can you explain further?
Is there any differences between NFT IP and conventional IP that we have today? So presumably the question is asking if you are seeing NFT as a form of IP, or is that, I don't know, maybe he's thinking of, is it sui generis IP or NFT as a copyright, or it's a contract?
Okay, I think
you license maybe.
Yeah, I think you can't run away that you see the threshold questions, right? It's always been not even started with intellectual property, started with the traditional property. Okay, your traditional property. Okay, traditional property, only then you can come to court and seek remedy. Okay, you see, again, I think to me this is just like evolutions, okay, from property to intellectual property, right? Okay, now that the next stage is that we try to extend intellectual property to cover NFT. Okay, again, I think I would say if let's say property is a big thing, then IP is a subset, and then when it comes for NFT, it can be a subset to intellectual property. I would see in that sense. So it's not totally new, meaning that all those principles applies to IP would equally applies to NFTs. See, that's why you see that all the cases they are talking about dilutions, they are talking about confusing the public, all these things. All these things actually is IP law. Okay, when even you see the NFT, the selling and buying, the thing is licensing. Okay, the IP licensing. Okay, it's a big business. The game is also governed by all the traditional contract law. So in that sense, I put it this way: NFT is a subset to IP, right? Then IP is subset to property. Okay, I think in that sense, I think must come from somewhere. Okay, you cannot create something from the air, right?
Thank you. Thanks for the explanation.
Yeah.
I think there is always this problematic question, as you say, it's a threshold question. Because if you look at historically in the legal system always recognize a physical object as a property, and that starts even without any specific area of law. Tort law recognize it as a form of chattel. Then we come to land, because land is something that you cannot move about. So to recognize land as a property, eventually it probably started off as some kind of contractual transaction between parties. Now I'm no longer using this, and I'll let you use it, and whether you're going to give me a payment and so on. And eventually land law developed. And when land law developed, I would say most countries will have some kind of land codes being written out, because that is the legal document to recognize land as a indisputable form of property. Then you move into virtual things, which are things you think it's there, but it's not physically there. So money is an example. The piece of paper which we call currency is just a piece of paper. So law needs to be passed and made to recognize the value behind the piece of paper. Then you have securities. So what are we buying? Is what we are buying as a security is just a contract document, or is it more than just a contract document that we can actually transfer to others and is binding also on recipients? Then we move on to intellectual property, where nowadays we would say very few areas of intellectual property are actually recognized as property until and unless there is a statute governing it. So, for example, Copyright Act itself declares that copyright is to be treated as a form of property, similarly as a trademark and patents and so on. So when we deal with this new world of virtual stuff on the internet, we are probably about at the threshold where it would be useful for parliaments to actually consider recognizing it as a form of property, where the boundaries are still very, very uncertain. To what extent it should be, to what extent it's transferable, and so on. I think some of these questions we are still looking and considering the answers, but they are moving away from intellectual property per se. I think one of the earliest form of this question is domain names, for example. Are domain names property? The other thing, if you think of it as intellectual property, yes, it may fall under trademark, but not necessarily trademark. It is domain names, for example, names of a company may be registered as a domain name. And what if it's not? It's a generic word, and I register as a domain name, for example, baya.com.my. I register as a domain name. So should I have a property right in that? And should law start recognizing it as a property right, that I can go to the bank and say, put it down as a form of security to get a loan to start my business? Right? I think this is a very interesting question where for the next couple of years, I'm sure again and again, these kind of questions are recurring, and thoughts really start dealing with it.
Yes. In fact, foundation, right? I think previously last month, right, I also had a discussion on metaverse. And one of the key things about metaverse is also like there are people are buying and selling land in metaverse, okay, and they are using NFT as something like a proof of ownership, right? This is a thing that's slowly developing. Is unthinkable, okay, a few years back, right? But it's happening slowly. And in fact, you ask around our developer friends, they are all gun ho and going in. I don't know what.
And they are not cheap at all.
Yeah, precisely. And also, you ask them. I talked to a lot of these so-called players. In fact, they only have the concept, prototype. To show to you, right? It's still very new, but still a lot of people are willing to throw in a lot of money. Yes, it's a new kids on the board. They call it's a future. Okay, this is something that I think we have to go through that stage lah. like NFT, like blockchain, like cryptocurrency, right? And also about you mentioned about slowly the developing of law, like maybe eventually we'll have a separate law altogether, right? For NFT instead of still categorized under copyright or trademark, whatever. I think it's possible. It's not impossible. I think a very good example would be strata title. You see, strata title started off as part of National Land Code, right? From National Land Code, then you have Strata Title Act 1985, right? So then eventually also we have a specific act, Strata Management Act 2013, right? All these things, evolve a lot of time when the needs, when there is a need, we need more specializations. We require a more specific law to regulate certain activities or certain properties. Then I think that time the parliament would go into that and regulate it. Really? I think this will be a more matured way of doing things step by step, and not to from now today, right? Oh, we see NFT is booming, so we quickly enact a law, right? Sorry to say, because it's not mature enough. A lot of things you have not encountered, you don't know how to tackle it. In fact, meaning you render the whole act ineffective and become white elephant. So I think the better way is we move a lot of time, try along the way, try and error, but also adapt and extend the existing legal principle. When the time comes, we'll enact a brand new act to cover that specific area. I think this is a better way forward.
Thank you very much for your comments and insights.
Yeah.
The time now is coming to an end. Thank you very much again. I don't see any other questions being posted right now. Yeah. So perhaps this is a time to close our session today. Yeah. So thank you very much again to everyone for attending and participating in today's webinar titled Insights Humanizing Innovation Session with the Industry. For today's session, we now know that smart contracts, blockchains, cryptocurrencies, and NFTs may play a very important role in the online metaverse economy of the future. It is important for industry players, students, members of the public to keep themselves abreast of the new development in this new Wild West. So once again, I would like to thank our host, Multimedia UCs, the smart, the smart team, the ICEC, who, as well as the technical team behind today's session for organizing and planning for this event. And also, we would like to thank the speaker, Mr. Khaw Su, for giving us a very insightful discussion on NFTs intellectual property. Thank you very much.
Thank you everyone. Thank you, Dr. Dennis. Thank you, MU. Thank you everyone. Thank you.